advertisers. It's time for Montgomery's conversational radio show. It's News and Views on News Talk 93.1 FM. To join the conversation, call 272-9228.
Joey Clark.
Welcome back, folks. And now, as promised, do this regular every other week sort of thing. We have Alan Mendenhall with the Heritage Foundation, and I've also we've known each other through many different circles. But Alan, how you doing today?
I'm doing very well, thank you.
Good to see you, sir. Good to see you. And let's remind folks what you're doing for Heritage Foundation. We talked about it a couple weeks ago, but let's remind them.
Sure. Yeah, I've got a couple roles. One is a senior advisor to the Capital Markets Initiative, which is about to be rebranded as the Free Enterprise Initiative. And then I'm a research fellow in the Rowe Center for Economic and Policy Studies.
Very good. And you had an op-ed that rightfully was trending at 1819 News last week. Alabama should rethink ABA accreditation for law schools. For folks who didn't catch me reading it or read it themselves, can we lay out the idea here?
Yeah, sure. Well, we would be following Texas and Florida. People who are paying attention are noticing that Texas and Florida have taken the lead in so many areas where Alabama very easily could take the lead, but we haven't. One of these areas is removing the American Bar Association as a accreditor of state law schools. So all 50 states have Supreme Courts that have the ultimate authority over who can sit for the bar exam in that state. And so there's no reason why our state Supreme Court couldn't do the same thing and say, hey, you know what? We're going to decide which law schools you can go to and graduate from to sit for our bar exam. Now, the reason why the ABA is a bad accreditor, there are a number of reasons, but its Standing Committee on the Federal Judiciary has been tasked with evaluating federal judges for a long time, and its evaluations are so incredibly biased against conservatives, and they'll rank a conservative as not qualified and then rank somebody who's clearly not qualified on the left as qualified, and it's so blatantly obvious. The ABA has public positions on abortion access, on all kinds of LGBTQ initiatives, on all kinds of DEI stuff. And so what this does is, when it comes to the accreditation, is it requires law schools to kind of buy into all the ABA stuff. So there's something called the Council section on legal education admissions to the bar. It is actually an appendage of the ABA. So they function in concert, but not necessarily as the same voice. But that council is what works with the bar, with the law schools to ensure compliance. And for a long time, it did things like it made law schools do all the stuff that was really, really costly, but not actually didn't make a lot of sense, like things about limiting online education, requiring the libraries to have certain amounts of books in them, and things like that. They were a little bit anachronistic, but that drove up the costs. And that's because this Council of Legal Education and Admissions to the Bar actually operates in a lot of ways like a union for law professors, in the sense that they want the legal education costs to go up so that law school can be more expensive and that law professors can enjoy all these great benefits. So that's one reason why you don't see as much pushback against the ABA from within the legal academy. Also, the fact that the legal academy is generally quite leftist in its orientation. But this is a very simple fix. It does not require any legislation. We don't have to sit there and watch lobbyists run up to, the state house and go from office to office. This would just require our 9 Republican Supreme Court justices to decide, hey, what's the point? We don't need the ABA. Right. We could grandfather in all the schools that are currently ABA accredited and then just add law schools or subtract law schools as we needed. Currently, Miles Law School graduates can sit for the bar, and it's not accredited. Faulkner's law school used to not be accredited, and their graduates could sit for the bar. And that was because the Alabama State Supreme Court said, hey, we'll let these schools do that. And there's no reason why they couldn't continue to do that and pick and choose law schools as they deem necessary.
Well, and I think it's been, especially through the COVID era, but a lot of folks have been getting wise to these so-called neutral institutions. You could take the ABA, or you could take like the American Medical Association. Any of these you can run through, and it seems not only have they abused that brand that they had for years of neutrality, it's almost created this informal network of nudges and winks. And I imagine that goes on with some of the law schools where, here's the formal policies, but if you don't play game with these other, say, arms or entities, our other voice, then, you might run afoul of something. We'll find a way. And that is like the worst possible outcome, where you have a monopoly that isn't neutral and also has a bunch of other informal asks against the folks that are supposedly enforcing the neutral rules.
And Alan, this is Troy Carrico. Thank you. I feel like I've arrived, Joey. He's following me now on X. I just feel so vindicated. Anyways, so the problem we have, and I went to law school for a year, and it's a long story at the University of Dayton, and then went to Ole Miss to get my master's degree in international relations. But my thoughts is, I've thought to myself when I was taking the LSAT, when you have one accrediting authority, just one group that decides everything, it's rife for infiltration. Mm-hmm. And what's happened here is we're getting a more liberal, and activist judiciary out there because of this system in place. So once again, I've got to tell you something, Alan. I went to this viewpoint, all the things you told us about last time you called. Outstanding work going on. Outstanding work on your end. So.
Oh, well, thank you very much. And you're exactly right that the ABA has that monopoly. And we're seeing moves in other areas of higher education to ensure more competition, and legislation in Florida, for example, that requires universities to take actions that enable competition to happen. But with law school, there is no other accreditor. I mean, you could in theory make the states more competitive against one another by having the state Supreme Courts decide the criteria by which they determine who can sit for a bar exam, and that might do some interesting things. But ultimately, the legal profession is still modeled off kind of the medieval guild model. It is a guild, and they do things that ultimately make legal services more expensive than they need to be. There are a lot of things that people could do through non-lawyers, like have their wills written, a lot of trusts and estates, a lot of property matters and things like that. Like some of that, like why you shouldn't really need an attorney for some of those things.
Well, so simple question. Why isn't Alabama they've done in little carve-outs like you explained, why didn't they move on this earlier in other conservative states? Are they just that scared of the guild?
Possibly, yeah. And I think it's the same logic that you hear all the time, which really is less logic and more rhetoric, that we're here to protect the public. Our profession exists to protect the public, and we're going to ensure the highest standards. And of course, I love standards. I think standards are great. We should have high standards, but I don't know that the ABA is the place that is really setting the highest standards when they are enforcing things like DEI, which involve the reduction of standards and the disregard of standards. Now, interestingly enough, the ABA's history is sort of muddied with ugly things. I mean, the American Bar Association really came about to prevent poor people and black people from becoming lawyers. And like in 1912, the ABA ousted 3 African Americans from membership and issued this resolution because they realized, oh, we didn't mean to admit three black people into our membership. If we had known, we would have never done it. And that is a really troubling past. And they, for 66 years, prevented black people from becoming members. And so a lot of what the ABA is doing, in my opinion, is to atone for its history, to atone for that. And so they go over the top with their leftism to try to erase that part of the history or make up for it or say, well, we're not like we used to be. But the fact of the matter is, the ABA exists to be exclusionary. You can take the I prong of DEI and say inclusion, but the whole point of the ABA is to prevent people from entering into the profession, at least initially. Now it does a lot of other things besides just accrediting law schools, and every state bar association regulates who goes in and out of the bar. But the ABA does